With that, I'll call the second case on this morning's docket, understanding that we'll need to move some people around, but that case is case number 129205 from Jefferson County in the matter of the marriage of J.E.G appellant and C.L.B.G appellee. Would the parties please come forward and state their appearances?
Please, the court, Devin Liam appears on behalf of the appellants.
Thank you.
Good morning, Jody Meyer, Law Office of Jody Meyer appears on behalf of the appellee, C.L.B.G.
Thank you very much. And would the appellant like any time for rebuttal?
6 minutes.
6 minutes. All right. With that, you may proceed.
The appeal that I filed covers two separate issues: the financial issues in this divorce case and the parenting issues. I want to start off with the parenting issues because I think, frankly, those are the most compelling and, frankly, were not addressed in the judgment that was provided by the trial court in this particular matter. Which
Let me stop you.
Yes.
So on the parenting issues, I understand there was a pretrial in this case, and a pretrial order was generated. So it looks like your two parenting issues are the right of first refusal and then the failure to get the second opinion for the autism diagnosis.
Correct.
Were those issues identified in your pretrial order?
I don't recall off the top of my head. I know that we addressed them in the parenting plan that we did file with the court.
And when did you file the parenting plan with the court?
I believe it was a couple of weeks before trial. I know that my client had some changes as far as some of the issues that he wanted to address in the parenting plan. So I did redraft the parenting plan and filed that with the court and provided that to counsel for, at that time, the appellant at the trial court. So.
Okay, so you believe it was filed before trial, or was it offered as an exhibit during the trial?
I believe I filed it before trial. If I'm wrong on that, I'm wrong on that, but that's my recollection of the way I proceeded on this matter.
Okay.
The reason why I believe the parenting issues are so compelling in this particular case are that there's a strong preference for finality when it comes to parenting orders. I know that to revisit a parenting order after it is set by the court, it takes a material change in circumstances going forward in the future, which is why it's vitally important that the parenting plan be complete and be as accurate as possible on the first bite at the apple, so to speak, because there is preference for finality, and there is preference that things don't be revisited unless there is a specific need to do so through a material change in circumstance, which is why the failure by the trial court to address either of these matters is somewhat disturbing, and frankly, from the appellant's point of view, an abuse of discretion.
Let me stop you again.
Oh, sure.
Okay, so let's focus on the right of first refusal.
Yes.
Which, a lot of us characterize that as the idea that if one parent can't exercise parenting time before alternative arrangements were made, the other parent gets an opportunity. Is that fair?
That's absolutely what we were seeking in this particular matter. And the reason for that is I think it's in the best interest of the child that the child be raised by one parent or the other. And before we bring third parties in to provide care for the child, I think it's an important right for the child to offer the right of first refusal to the other parent in the case that there is an extended absence that's needed by the one parent.
Okay.
That's the reason why I addressed that with the court.
So what was the evidence that was presented at trial to support that request? What was your client's testimony? What was presented?
It was my client's testimony. I believe that he testified that, again, he's a concerned father. He wanted to have as much time in his child's life as he could, and he believed that if there was something to where she needed to be somewhere else and could not watch the child, that he should be given the opportunity to watch the child before having a third-party babysitter or other person be involved.
Okay, and so then the court issues a parenting plan, right, at the conclusion of all this, and doesn't award your client this right of first refusal. Did you ever object that the court's factual findings weren't sufficient?
I mean, at the time, you obviously did not find out that the court did not address it until we got the judgment. And my recourse for addressing it, in my opinion, was through the appellate process. And that's why I did file that particular provision in the appeal motion, was so that this court could take a look at the facts, take a look at the record, and make a decision as to whether or not failure to address that issue in its final judgment represented an abuse of discretion. So it was my opinion that this particular court was my immediate remedy to address those particular issues.
Okay, and I want to make sure we give you time to cover everything. So on the second parenting issue, the failure to address getting a second opinion for the children's autism diagnoses, what evidence did you offer at trial that this second opinion was warranted?
I think there was a testimony. My recollection is that both parties, during either cross-examination of the appellee or direct examination of the appellant, talked about the fact that this was a multilingual home, that English and Spanish were both spoken, but Spanish was the primary language that was spoken in the home. And that's a key factor in deciding on whether or not this was a proper diagnosis, because I believe the testimony of the expert that testified on the issue of the autism diagnosis, everybody was clear that the test was given in English. And there was some complicated issues that were discussed in this particular investigation and diagnostic tool of the child, such that if the child did not understand the language, that it could affect the outcome.
But the respondent brought a witness, the children's doctor, Dr. Ashley Bloom, and that doctor testified about the diagnosis.
Right.
Did you offer any evidence, medical evidence, to controvert that?
No medical evidence to controvert it, but I think the record was clear that Ms. Bloom did the evaluation in English. And with this being a multicultural home, that's the reason why we wanted the second opinion, to make sure that the children understood the questions that they were being asked of them. That wasn't clear from any of the testimony in any of the record that was offered in this particular matter. There would have been no prejudice to the appellee to allow that to happen. I believe my client said that would be at his cost, that we would do that. Autism is a vitally important issue to get right. It doesn't carry the scarlet letter that it did years and years and years ago. But autistic children see the world in a different manner. They process information in a different manner. And their educational focus needs to be done differently than those who are not autistic. So it is, in our opinion, it is better to do two evaluations and make sure that we get it right than to depend on the one evaluation where it's not clear that the children understood or given the opportunity to process the information, their primary language that was spoken at home, which is Spanish. It's in the child's best interest that we get it right on the front end, so that, I mean, if the children are autistic, that's not, again, a scarlet letter. That's not something that's going to sentence them to being behind in the educational system. Our educational system has come a long ways in addressing these through IEPs, through 504 plans, and make sure I get the number right. But there.
Did Mother state on the record that she didn't object to a second opinion?
I thought she did. I thought she didn't care if there was a second opinion, especially given the fact that my client was willing to pay for that. That's why it was concerning that the district court did not address it in their findings, because it's not clear from the record whether the judge reviewed it and made the decision that it was not appropriate, or that he just did not address it or forgot to address it in the record, and it needs to be revisited. That's why we're asking the court to remand this matter back to the trial court to make specific findings as to its opinion, whether or not a second opinion on autism is warranted. That's the remedy that we're seeking from this court on that particular issue. I think I've exhausted the parenting issues. Turning to the financial issues, Obviously, equitable division is addressed in the Kansas statutes 2711 plus case law. It does not have to be 50-50. There is a 10-factor test for the division split under 23-2802C. I believe that it was factor 8 was the analysis for the inequitable split based on dissipation of assets.
I'm going to stop you. I just want you to know that we're through your opening argument time now, but if this is something that you'd like to address now, we can just kind of take a little bit of time out of your rebuttal so that you can address it now.
Sure, that's fine. Probably I can do this in a minute. I think the crux of my argument is that the court did not abuse this discretion in ignoring my client's testimony as to Exhibit L, which was the main document that was offered by the other side with respect to the reason for the inequitable division in this particular case.
When my client testified, did he discuss the fact he stopped, it looks like paying the mortgage, stopped depositing into the joint account, providing support, withdrew his paycheck from the joint account, stopped paying health insurance premiums, daycare, school fees, and then bought a vehicle? Did he testify about that?
I believe he did. I know that there was discussions that the accounts were switched from the marital account because of the conflict going on in the marriage with respect to the accounts, that he switched it to his own individual account, but that he did continue paying for some of the costs. That's my recollection of the testimony in the case. I guess to wrap it up, to save myself some time for rebuttal, my position is that the court did not properly consider the evidence and testimony in the case and did not follow the factor analysis correctly in deciding to do an inequitable division in this case. And I will defer the rest of my time for rebuttal. Thank you, judges.
Counsel, I think you have reserved 4 minutes for rebuttal.
Thank you.
You're welcome. Good morning.
Good morning, may it please the court. Appellant raises essentially 3 issues on appeal, and the standard of review for all 3 of those issues is an abuse of discretion by the trial court. It's the appellant's burden to designate a record sufficient to establish a claimed error, and without that record, his claim of alleged error fails. Assertions in an appellate brief are not sufficient to satisfy inadequacies in the record on appeal. So therefore, appellant has not met his burden in any respect to these issues. I'm going to go ahead and address the issues of the child-related issues, since that was the majority of appellant's argument. And there are 2 really separate issues. Regarding the autism evaluation, I would note that I think that was brought up in the pretrial statements, and certainly there was a lot of testimony at trial about that. And I would admit that that the appellee at trial said she didn't have an objection to that. However, there was extensive testimony that there was more to the autism evaluation than simply whether or not there was a language issue with the children. As noted in the transcript, the children were very young. The 2 children were very young at the time that they had the evaluation. Dr. Bloom, the pediatrician who testified at trial, was not the person who did the autism evaluation. I think it's specific to clear that up. The University of Kansas did that autism evaluation. Dr. Bloom testified at trial that she had noticed things in her assessments of the children that caused her concerns about autism. That led to recommendations at the University of Kansas to get those evaluations done. Then there were other folks involved. The appellee testified at trial that the children had various professionals who provided support. I think there were speech and occupational therapists. All of these people witnessed these things to support the idea that the autism was there. There is no basis other than the appellant's opinion that there was an issue during the assessment with the children and the language barrier. I'd also note that Dr. Bloom in her testimony at trial noted that she has a degree in Spanish as well as her undergraduate degree. So I think that Dr. Bloom was well aware of potential issues that could arise. So I would also note that the trial court asked some pointed questions to the parties regarding the evaluation and noted that he had family members who had autism as well. So I think it is safe to consider the fact that the court, even if my client did not have an objection to evaluation, looked at the substantial competent evidence and made a determination that a second autism evaluation was not necessary. And so, in looking at all that evidence from the trial court on that issue, I do not believe that anyone could say that the trial court abused its discretion in not granting that. Now, did the trial court make a specific finding that it was not going to grant the autism evaluation? No, the court did not do that. However, the appellant could have asked the court in a motion pursuant to 60-252B to make additional findings, amend the findings, did not do that. In addition, he did not object in any way to the, I guess, if you want to call it, inadequate findings of the trial court. And it's in the absence of that omission should not be considered on appeal. Regarding the issue about the right of first refusal, I would note that that was not an issue, according to the trial transcript, that there was testimony about. And there, in my review of the record on appeal, the appellant's proposed parenting plan was not filed with the district court. It appears that it was an exhibit at the trial, that both parties produced a parenting plan at trial, and appellee's was filed with the district court. And it appears from the testimony that there were multiple things in the appellant's parenting plan, because there were some references to specific things. It sounded like there were a lot of various items in there, and that the court, reviewing those parenting plans, decided based on the testimony of the parties that he was not going to adopt that particular provision of the appellant's parenting plan. And if you look at the evidence before the court, there was a great deal of testimony from the appellee regarding the history between the parties, domestic violence, other issues between them involving exchanges at police departments or calling the police. And so if you consider all those factors, and additionally, I might add the distance between where the parties reside, I think that you could say that there was substantial confidence as the trial court had to decide not to adopt that specific provision of the parenting plan. And like the issue with the autism evaluation request, the appellant did not request the court to make additional findings as to specifically why he didn't adopt a right of first refusal. And therefore, in some ways, I think that he waives that argument. I'll move on then to the issue of the, I guess, property division. Like some of the other issues, there's not a sufficient record on appeal regarding what they believed the trial court's position to be in terms of how he abused his discretion in that division. There was nothing provided by the appellant prior to the trial that specifically suggested what his proposed division was. At the trial, he offered a great deal of testimony regarding the ins and outs of this joint bank account, or what's characterized as withdrawals from an account. And he essentially stated that he was worried that the appellee was spending too much money, and so he was giving it to his father, using it for various things. But at no point in the trial testimony did he really say what he was specifically wanting in regard to these various issues, other than his repeated assertion that he wanted an equitable division. And I think it's very important to note that at the conclusion of the trial court judge, after hearing all this, requested both parties to provide to the court, filed with the court, their proposed division or accounting, if you will, of the numbers and who's to get what. And there's nothing in the record on appeal with the district court or otherwise that indicates that the appellant ever filed such a document. There is evidence to show that the appellee's attorney did in fact file her proposed, I would call it findings of fact and conclusions of law in the form of a proposed decree that included all of those financial matters.
Let's pause for a second. So it looks like the appellee received $15,951 and some change. Does that represent half of the funds that, she alleged petitioner withdrew from the marital account? How did the court get to that?
Well, to be frank, I am not certain how the court arrived at that conclusion. The exhibit that's been referenced was not included in the record on appeal. And so I don't know. I mean, there's a general statement in that decree that was filed with those findings that that's what it was for, representing 1/2 of the expenditures. So
And this exhibit L was a ledger of the transactions. Is that correct?
it was a ledger of the transactions that I believe was prepared by Appley's trial counsel. That was an agreed exhibit for the court. And I don't believe that the appellant provided any documentation of himself other than his testimony to essentially explain or refute these various transactions that were in this exhibit. So essentially, in looking at the brief that was provided by appellant, I mean, it's not entirely clear what it is he's even asking today, other than the references to the withdrawals from the account. I assume that that is the issue, the only issue, as opposed to all the various other items in which the court ordered be paid to my client before dispensing equal shares from the sale of the residence. For example, repayment for the down payment on the car loan payments, expenses for the children, all of those are things that the court ordered that she be reimbursed for. I assume, because that hasn't been brought up today, that those are non-issues and that we're strictly just focused on the issue relating to the withdrawals, if you will, of the account. But again, did the court have substantial evidence to make the decisions that it did? And if you look at all the testimony by the appellee at trial, there was extensive conversations regarding the financial situation that she was put in. I will say prior to the filing, but during the filing, when the appellant stopped putting his paycheck into the joint account, was making withdrawals from the joint account after he stopped doing that, which means that she was solely paying those things, wasn't paying the other things. The record also indicates she was having to get financial assistance from her tribe, other people that left her to the position where she couldn't even pay the mortgage and was having to have deferrals on that. And as noted by appellant's or appellee's trial counsel in closing, appellant's actions were in violation of the temporary restraining order in the case that ordered that the parties were to continue the status quo essentially and not change the manner in which finances were happening, like say, for example, the deposit of his check into his own account. Appellant's testimony at trial was, yes, he did that, but he was specifically asked and specifically testified that his financial situation was quite good, that he wasn't living paycheck to paycheck, and there was no, so essentially there was no financial burden on his part. So I think for the trial court and hearing all of that evidence of both parties and considering the exhibit, thought that the appropriate thing was to reimburse her for 1/2 of those withdrawals. Wasn't the whole entire amount, it was 1/2 of those withdrawals. So in light of everything that this court has before it, I don't think there's any way that anyone can say that the trial court abused its discretion in making the decisions that it did. And I'll stand for any questions that you have.
Thank you. Further questions for the panel? All right, thank you. Counsel, you've reserved 4 minutes for rebuttal.
Starting with the financial side of it, I think the court, it was even brought up in the last argument that it's not clear from the record how the court arrived at the $15,000 division figure. I guess that's where we're coming from. I think the lion's share of the evidence was dependent upon that exhibit L that was presented at trial.
Counsel, did your client or did you provide anything to the district court to make a decision about the division of property following the trial?
I do not recall. I don't recall the courts. I don't recall the court specifically asking for that. So the answer would be no, I don't believe we did. We relied on the fact that we presented Exhibit L. The other side presented Exhibit L, and we took great pains to go through Exhibit L at trial to explain that this was not a dissipation of funds. This was not a violation of the court order that was in place in the pretrial. This was how he made sure that he was able to have finances for himself, but that the other side was still provided for. I don't think the evidence was sufficient, and the court did not make it clear in its judgment how it arrived at the $15,000 figure, which is why we believe that that did represent an abuse of discretion. Now,
What financial records did you include in the record on appeal for our review?
I gave great reference to the Exhibit L, which I believe was part of the record. I do want to turn my attention to since I've got 2 minutes left, I want to make sure I address the parenting issues. I hope I addressed the court's question on that, but the autism issue is, both autism and right of first refusal are both important, but again, I think it's extremely important that we get the autism question right on the front end, because as the appellee noted, and the testimony in this case was the children were very young at the time they were given the evaluation. Given that
In the
Spanish was
absence
the
of a ruling by the district court, has your client sought a second opinion? Is there anything to prevent your client from seeking a second opinion?
I think he's wanting to follow the parenting plan as closely as possible. And I think he's concerned, and I think
Counsel, is there anything to prevent your client right now from seeking a second opinion?
I guess just the objection which hasn't been made, but I know that every time that he has raised issues with the appellee on all issues related to the parenting plan, she's come back and said, we have to follow the parenting plan. So the fact that
in the parenting plan that prevents your client right now from getting a second opinion?
I don't believe there's any language in there specifically preventing him from doing it.
So what relief are you seeking?
We're seeking a remand to the district court to make specific findings authorizing how it's going to be done, if it's going to be allowed, and if so, how the payment's going to be made for that. If there's no language in there, I suppose my client could go get that done, but he doesn't want to open a can of worms that will lead them back to the district court. I guess the big thing is this was a very contentious divorce, and it's been contentious after the divorce with respect to the parenting plan. And my client's trying to be extremely careful to make sure that he does not do anything that's going to cause him to have to go back to court to state that he is violating the parenting plan that was issued by the court, which is why we just want some definitive language in the parenting plan that addresses how a second opinion on the autism would go, because his time with the children is far less than his wife, and he wants to make his ex-wife, and he wants to make sure he does things following the parenting plan. Thank you. It looks like I'm out of time.
All right, thank you very much.
Thank you.
The court will take the matter under advisement. I want to thank counsel for their arguments today and in the briefs, and we'll issue an opinion as soon as we're able.
Thank you, Your Honors.